Welcome to Doughty Street for the first in a series of seminars on the Mental Health Bill. This first event in the series is going to provide a general overview of the bill, and then it's going to be followed by what are called deep dive sessions on specific aspects. So the next seminar will be on the 27th of February, and that will deal with detention and consent treatment. And then there'll be further seminars on learning disability and autism, tribunals and aftercare, and mental health and structural racism. 27th of February, yeah, okay. The other ones, the dates are just being decided at the moment. We will email the dates to you because we have your details on today's list. Got 3 presentations for you tonight, each of them from a distinguished speaker with a long experience of Mental Health Act law as well as mental capacity law. The talks are going to be roughly 15 to 20 minutes each, and then there'll be 10 minutes for questions after each talk. If you're attending the seminar online, you can unmute yourself to ask a question, or you can ask a question in the chat box if you prefer to be more low-key. So our first speaker tonight is Sophy Miles. She was a member of the Tribunals and Patient Safeguards Working Group, which was part of the Westley Review. And she's a Court of Protection and Mental Health Review Tribunal judge who, for many years before she became a barrister, was a well-known solicitor who established Miles and Partners. She's also a co-author of the Court of Protection Handbook. So Sophie's going to talk to us. She's going to give us a general background to the bill and also talk about the admission criteria and the nominated person.
Thank you very much, Anselm, for that very kind introduction. And this is where I find out whether the slides are going to click through or not. And then, yes, they are. Excellent. Right. So I'm going to start by just talking a little bit about how we got to where we are at the moment with a mental health bill going through the House of Lords. And we have to go quite a long way back, actually, to 2017, an announcement by the then Prime Minister, Theresa May, who had just announced a very surprising general election, for those of you who remember that. And she pledged, and we've got a little quote from her on the slide, she was pledging to rip up the 1983 Mental Health Act. She said that on her first day at Downing Street, she described shortfalls in mental health services as a burning injustice. So she was going to pledge to rip up the 1983 Act and introduce a new law which confronts discrimination and unnecessary detention, which takes place all too often. What she did was to appoint the distinguished psychiatrist Sir Simon Westley to carry out an independent review of the Mental Health Act, which he did over a period of 18 months. And as Anselm has said, I was fortunate enough to have the chance to serve on one of the working groups looking at the safeguards for patients and whether, how they were working and what recommendations were. And we had a very distinguished chair in the form of Anselm himself. And we made quite a lot of recommendations, some of which do seem to have made the final cut, actually, which is quite nice. So here we go. This is what Sir Simon said in December 2018. He said he'd been tasked to see if the Act was up to date and how it deals with human rights. Spoiler, it isn't. You know, one of his overarching points was that you in order to reduce risk, you have to sometimes take risks. He talked about the painful reality of the impact of the combination of unconscious bias, structural and institutional racism, which is visible across society, also applies in mental health care. And I mean, his review is, it is really worth going back to and looking at. It's a really detailed survey, and he spent a lot of time talking to people who had survived the mental health system. And there's a lot about the views of people at the sharp end of the system in the review. And he says he was confident that the recommendations would shift the dial in favour of greater respect for wishes, choices and preferences. And one of the things we are going to be asking over the next sort of few months with these seminars is, is this shifting the dial? What difference will these changes make? And also, what can we do to improve the bill as it goes through Parliament now? I managed to get that slide to move with only one click, so I'm really pleased about that. So 8 years, 5 prime ministers later, the mental health bill has had its second reading in the House of Lords. So it's at the moment going through the House of Lords. It's currently at the committee stage. There was actually a committee yesterday, and I will mention some of the things or questions that they were asking. Reports, it will then go into the report stage and the final reading in the House of Lords, and then on to the House of Commons. At present, the Joint Committee on Human Rights has an open call for evidence, which will close on the 24th of January, so not very long. And then they'll be hearing evidence. At least some members of chambers have been invited to give evidence to the Human Rights Committee on some of the issues that they're looking at. If you want resources on the mental health bill, you can do no better than look at the web page maintained by the amazing Alex Ruck-Keene, who at 39 Essex, who I'm sure all of you will know. He has got a page with the draft bill, explanatory notes all brought together, so it is worth checking out. You can also find an easy read version of the bill at the link that I've given you, and these slides will all be emailed over. So if you'll be able to click through to find any of those links. So I'm going to look at 2 aspects of the bill. And the first is that the detention criteria and some of the definitions. And then the second is going to be on the new nominated persons changes. So a lot of new definitions to get our heads around if this all goes through. The bill defines learning disability as a state of arrested or incomplete development of the mind, including significant impairment of intelligence, and autism as a lifelong developmental disorder of the mind, affecting how people perceive, communicate and interact with others. Now, the reason why it puts those definitions there is because those 2 conditions are essentially sort of hived off and will not be treated as mental disorder for the purpose of detention under the Mental Health Act in a large number of cases. So anything other than a learning disability or autism is referred to as psychiatric disorder. So that's a definition that we'll start to see. there's a reference in some cases, learning disability will be a kind of a gateway to being admitted under the new Mental Health Act if it's associated with abnormally aggressive or seriously irresponsible conduct. So another new definition is appropriate medical treatment. And this is a change, because appropriate medical treatment at the moment basically means, pretty much anything, okay? That is doing its best to try and, stop people getting worse or hopefully improve their symptoms. But the new definition will be treatment which, taking into account the nature and degree of the disorder and other circumstances, has a reasonable prospect of alleviating or preventing the worsening of the disorder or one or more of its symptoms. And is appropriate in the person's case. So that is a ratcheting up of the threshold to judge that appropriate medical treatment is being delivered or is available. So I'll quickly look at the detention criteria in civil cases. The proposal is, so for someone being detained, who's being considered for detention under Section 2, assessment or assessment followed by treatment, presence of any mental disorder. So can still include those who have learning disability or autism. But the risk criteria, the threshold for them being admitted is that serious harm may be caused to the health or safety of the patient or another person unless the person's detained, and given the nature, degree and likelihood of that harm and how soon it would occur, the patient ought to be so detained. So you're already looking at a specific test of serious harm if the person isn't detained. And then if we look at the criteria, that terminology, that gateway test flows through into the other forms of detention. So if you're going to be detained under Section 3, again, now you've got to be suffering from a psychiatric disorder. So learning disabilities or autism will no longer be a reason to detain someone under the Mental Health Act for treatment under Section 3. And again, here is the test. Serious harm may be caused to the health or safety of the patient, and it's necessary given the nature, degree, and the likelihood of the harm and how soon it would occur for the patient to receive medical treatment. And the appropriate treatment, the necessary treatment, can't be provided unless the patient's detained under the Act. And that appropriate treatment, that treatment that's got a reasonable possibility of alleviating those problems, that treatment is available. Guardianship can include people with psychiatric disorder, autism, learning disability, which has serious behavioural consequences. If you have autism, you may still be received into guardianship under this new bill. If you have a learning disability, you're only at risk of being received into guardianship if your disability has what's called those serious behavioural consequences. Admissions through the criminal justice system is different. Again, there's a new concept here, a relevant mental disorder. So the relevant mental disorder is psychiatric disorder or autism or learning disability, which has serious behavioural consequences. So we now have a change. We have a different cohort of people who are liable to be detained through the criminal justice system, through hospital orders, to those who are who might be detained under the civil sections. And that's obviously going to flow right the way through their admission. And we're going to end up potentially with people on the same ward who are, say, detained, some detained under Section 3 and some detained under Section 37 through a hospital order, possibly some time ago. They might be on the same ward doing the same sorts of things on the same treatment, but the criteria for their detention is going to be different. CTOs, again, one of the things about CTOs was they were highly criticised in the review. Again, you've got to have a psychiatric disorder. It's the same test of serious harm necessary to have medical treatment, and that medical treatment's got to be appropriate. There's a new requirement, though, and that is that a CTO can't be put in place unless your nominated person, which we'll be coming on to in a moment, has consented or been overridden. Now, just really quickly on the serious harm test, well, that's a new definition for this purpose, but the serious harm test is already part of the Mental Health Act, because if a criminal court, a Crown Court, is considering giving a restriction order to protect the public under Section 41 of the current Act, it can only do so where it's necessary for the protection of the public from serious harm. And a couple of examples from case law, where the harm is physical or psychological injury, the test is of death or serious injury, but serious harm can also include indirect harm, such as downloading harmful material. Now, that was actually discussed, that test was discussed in the House of Lords yesterday. The question was asked, why isn't it the test of significant harm? And the answer was that serious harm is felt to be something where there's already some legal definitions in place, and there's going to be a new code of practice which will give guidance as to how it's applied. So does this shift the dial? Is this going to mean fewer people being admitted? And let's not forget that the review also made the point that one of the things that was going to stop large numbers of admissions was more accessible and responsive mental health crisis teams that can respond to people's needs and keep them well. The review said you should really be treating people with consent where possible. They shouldn't be brought into hospital and detained unless they're objecting. There should be a substantial likelihood of significant harm to the patient or others as the criteria. And CTOs were described as being in the last chance saloon. The review felt they were not working well. There needed to be really robust research that they were actually achieving anything. So, you know, I mean, I think actually the new criteria are a change. I think they will tighten the definition up, but will remain to be seen. I'm going to now just turn to the nominated person. And this again, I think, you know, there are some real changes coming here. I know we've got quite a lot of people from local authorities joining remotely, and I hope this is helpful to you. So basically, if the bill is passed as it is now, then the nearest relative provisions will be abolished. On day one, no one has a nearest relative, and no one will have a nominated person because they probably won't have got their act together to go through the process. So you'll be delighted to know there's a schedule with the details. It's Schedule A1, which has the eligibility criteria for appointment as a nominated person. The appointment's got to be in writing. It's got to be witnessed by an independent mental health advocate or a health or care professional who's got to certify that you, person who's appointing a nominated person, has capacity to do so. Now, an AMP who is considering an admission has a power but not a duty to appoint a nominated person for someone who's lacking capacity to do so. And there's a pecking order for the AMP if they're doing that. If there is a deputy or donee of an attorney who's actually got the authority to act as a nominated person, then they must be appointed. If there's a local authority has parental responsibility for an under 18, they must be appointed, even if there are other people that they're sharing parental responsibility with. The new code of practice is going to provide guidance for people who are appointed as nominated persons, and they are going to have regard to that guidance just the same as everybody else. The nominated person does have some new powers, so they now must be consulted if someone's going to be put on a CTO, unless it's impracticable or going to cause unreasonable delay. They have the right to be consulted about some transfers for people who are some forensic patients, and they've got a right to require, only reasonably, a review of the patient's care and treatment plan. But if you are the nominated person and you are told, well, I'm considering detaining, your sister, whatever, under the Mental Health Act, I can't do it. I need to know if you object or not. If you object, then that objection, rather than triggering an application to the county court to displace you, that can be overridden if it's certified that the patient would act in a manner, would be likely to act in a manner that was dangerous to themselves or others, if they're not detained. So, given that the serious harm test is already part of the admission criteria, how much of a safeguard is that power to object under the new provisions? Very quickly, because I'm probably overrunning. I know that, again, as with the current process, a person could be disqualified from acting as the nearest relative by an application to the county court. Various new grounds for disqualification, including have they done anything that's clearly inconsistent with remaining as a nominated person? Well, what might that be? Might it be a breach of something that's in the new code of practice? Or you lack capacity to act, or you're otherwise unsuitable. So a few short questions on the nominated person. How many people are really going to go through that process of appointing somebody and getting that appointment to be witnessed and certifying their capacity? And are they going to be from the marginalised communities that the independent review was really worried about? We will see. We'll see how popular it is. Is the role to some extent being professionalised? And I suppose, is that inevitable if it's going to be through choice? What kind of guidance is going to be given? And is it going to be too easy to override the objections? So those are the kind of questions that I think are worth thinking about, and perhaps considering whether anyone has any ideas for amendments to those provisions, whatever, because there's everything to play for, because the bill is still going through Parliament. Thank you very much. I'll come back and we'll take any quick questions.
Thank you very much, Sophie. Any questions from the audience here?
Steve.
In relation to nominated persons, are there going to be any ancillary changes to the normal scope of appointment for deputies or attorneys? Because they're obviously, in the running. But at the moment, I'm puzzled as to whether the normal scope of appointment will include this sort of power.
Well, they're only going to include that power if the court is actually asked to include it as a deputy. And likewise, at the moment, it's not on the standard LPA form. So I wonder how many people that's really going to capture.
And also there's going to be a whole cohort of existing appointments where that will not have been
absolutely
envisaged.
Yeah,
so
absolutely.
Is there any proposals for a way to sort of join the two up?
Not that I'm aware of, but I wouldn't like to say that there won't be some.
Okay.
It might be a good idea to amend the LPA forms to include that, actually, because maybe that will catch more people in getting them to think about what they would want to happen if they did lose capacity and needed admission as a mental health act. Because I agree with you, Sophie, it seems quite unlikely at the moment that people are going to go through that process of getting their capacity certified and nominating someone in advance of an admission.
Okay, any other questions here? Or
Questions
if you're listening online, you can unmute yourself and ask a question. Yes, got a question here.
Simone.
Hi, I'm Simone from the Free Our People campaign, which is a campaign that's led by people learning difficulties and autistic people to get out of the psychiatric system. I think from our perspective, the bill starts from the wrong place. It really starts from locking people up, as opposed to the right to be in the community. And at some point, it would be great, maybe some point, because the government did say that the bill is compatible with the UNCRPD, UN Convention Rights of Persons with Disabilities. We did ask a parliamentary question of whether there was anything published about their legal advice given to support their claim that the bill is compatible with UNCRPD, and the government have published nothing. So I just wondered if anybody else has kind of done anything around this issue, and we'd be very interested in working with anybody with this regards to the now we know the Joint Committee on Human Rights, as we might expect, nothing an easy read. Our community knew nothing about this Joint Committee because, yeah, we would definitely be interested in submitting around UNCRPD compliance.
Thank you, Simone. And I think the answer is, I mean, I would be surprised if they, if the mental health bill does comply with the UNCRPD, because, as you say, by its very nature. But
Well,
Yeah.
Oliver's going to give the next talk. Maybe you could address that as part of your talk, because he was involved in the negotiations leading to the UNCRPD, so he's very well placed to comment on that. There's a couple of observations online and one question. There seems to be some skepticism about the serious harm test and whether that in practice will prove to be quite a slippery concept. There's also an AMP saying that he or she wouldn't want the power to disregard the nominated person objection. And a question, somebody asking what happens when somebody already has a registered LPA. When the new act comes in, will that affect who is the nominated person?
so there won't be a nominated person until someone's appointed. If you still have capacity at that point, when the act comes into force, you can of course appoint your own nominated person, and it doesn't have to be anything to do with the LPA. But if you got to the point where you lacked capacity, then an AMP could appoint somebody as your nominated person. They'd first look at the attorney, see if the attorney actually had the power to act in that way, and if not, they'd have to make another selection. So it doesn't mean you wouldn't get a nominated person. It's just that the attorney would have kind of first claim on it if they're authorised by their instrument to do so.
That's a fire notification. Yeah.
Yes, it is, exactly. And the review recommended that it was actually a duty, because the review was worried about vulnerable people in a position where they are possibly about to be admitted to hospital, and but didn't have that safeguard of the nominated person because for whatever reason they hadn't got round to it. But that was obviously something that hasn't been taken forward.
Another question online here. You mentioned crisis teams and assertive outreach. Do the panel feel there will be any extra funding for those teams? Has there been any commitment to that?
Well, I mean, that's one of the questions that was being asked yesterday, actually, in the House of Lords.
Clear answer there.
There were some warm words, and an intention was expressed to make sure that everything would be for the best.
I mean, that always reminds me, Joe Biden's favourite phrase was when somebody said they valued something, his response would be, show me your budget and I'll tell you what you value. It's, it's an issue. It's easy to say you value something. When you look at the budget, you find that no money has been allocated.
I mean, yeah. I mean, we will have to just see, won't we? Hope,
Yeah.
I like to be optimistic about these things, but.
And the final question online, and then I think we'll need to move on to Oliver's
I think
talk.
it's going to be Liz first.
I don't mind.
Is there any mention about more mental health and learning disability bed availability in the near future?
No, but my understanding is that assuming the Act is in force in the format that it currently is in, it's going to be introduced incrementally.
Yeah.
And the idea is that the learning disability and autism provisions won't be brought in until there's enough provision away from hospital and in the community for those for those to work.
Right.
So I didn't read that as being any kind of commitment to increase the bed numbers within the hospital estate for that group.
Okay. Thank you very much, Sophie. So it's Oliver's turn now.
I'm happy to go.
I think it's Liz next.
Oh,
Okay.
have we switched the? Okay.
Okay, can we get Liz's slides up?
So in fact, Elizabeth is going to speak next. So Elizabeth, you're going to talk about mental health tribunals. Thank you very much.
Thank you, Anselm, and thank you for stepping in and chairing this evening as well. And as Winnie's absence, unfortunately, she was unwell. And also many thanks to Ray for organising, and particularly for doing the easy read versions of the slides. So I appreciate a lot of work went into those. So thank you. We've got a real wealth of experience in the room here and online. I think both lawyers from different backgrounds and specialisms, and also some experts by experience, which I think is really interesting and really helpful for us in thinking about this bill. We are obviously still in the early stages of this. Everything's still up for grabs, as it were, in terms of the amendments. It'll be really interesting to hear, I think, through the course of this series of talks about anyone's views, different perspectives about how the bill can be improved and what other change we might wish to see to mental health legislation going forwards. I was particularly moved to see Lisa Perry in the audience this evening. I hope you don't mind me mentioning that, Lisa. So before coming to the bar a year ago, I was a solicitor for 10 years, specialising in mental health. I represented Lisa's son, we're alongside Oliver, for many years during the pandemic. And he was detained in really awful conditions in a Section 136 suite. It was the first time that I was able to meet Lisa this evening, actually in person. We've met online so many times, so it's really great to have you here, and also to hear from you and others who've had that pointed interaction, if you like, with the mental health system over the years, and the impact that's had on you and your families as well. So I'm going to talk a little bit about proposed changes to mental health tribunals. Some of it's a little bit technical, and bear with us. And obviously all of these changes might well change in terms of the proposals going forward. So let me see if I can get a ticket to work. I can, excellent. So starting off, there's going to be increased access to the tribunal, really importantly. We're going to have more reviews, more opportunity to make an application for review before the tribunal. So first of all, for patients detained under Section 2, they will have now an opportunity to make an application within the first 21 days of their detention, extended from 14 days. So that really just avoids the need for making one of those slightly time-consuming references to Secretary of State for Health if you've missed the 14-day deadline. So common sense, I think, has prevailed there for that. For Section 3 patients, of course, we now have a 3-month period of detention instead of 6 months. So there's going to be an increased access to the tribunal in light of that. Section 3 patients will be able to apply in the first 3 months of their detention, obviously in the second 3 months, and then every 6 months thereafter, rather than 6, 6 and 12 as it is at the moment. The nominated person is going to have access to the tribunal where the admission or the CTO or the guardianship order was put in place despite the objections that they raised to the detention CTO or guardianship. There's also going to be increased references to the tribunal. So if the patient hasn't made an application within a certain period and their case is referred to the tribunal, there will be an increased number of references, and again, increased access to the tribunal for those patients as well. So for a Section 3 patient, there's a reference to the tribunal by the hospital managers after 3 months, reduced from 6 months. and then every 12 months thereafter, reduced from 3 years at the moment, which is a really long period if you haven't applied for a review of your detention in that time. And then for restricted patients, there will be references every 12 months by the Secretary of State, which is again down from 3 years, but no changes to the patient's eligibility to apply to the tribunal for restricted patients. Now, there's going to be some proposed changes to tribunal powers as well. So Section 72, which sets out the test that the tribunal needs to apply when it's considering an application for discharge, that has been changed effectively to mirror the detention criteria, which again, I think is common sense has prevailed there, in that it never really made that much sense. There was a different test for admission, slightly different wording for admission, and then for discharge on the way out through your tribunal. So, for example, looking at the Section 2 grounds, so the tribunal will direct discharge of a patient that's liable to be detained under Section 2 if it's not satisfied that the grounds under Section 2, paragraph 2 are made out. So effectively, you're referred back to the detention criteria for Section 2 admission. So is patient suffering from mental disorder of a nature or degree which warrants detention of the patient in hospital for assessment, or for assessment followed by medical treatment, at least for a limited period, and serious harm. That new serious harm test may be caused to the health or safety of the patient or of another person, unless that patient is so detained, and given the nature, degree and likelihood of the harm, the patient ought to be so detained. So really reflecting back to the admission criteria when considering an application for discharge. And then again, similar principle for admissions for treatment. Effectively, you're referred back to the conditions that are in Section 20, paragraph 4. So is a patient suffering from psychiatric disorder of a nature or degree which makes it appropriate for the patient to receive medical treatment in hospital, and serious harm may be caused to the health or safety of the patient or of another person unless the patient receives that medical treatment. It's necessary, given the nature, degree and likelihood of the harm for the patient, to receive medical treatment. The necessary treatment cannot be provided unless the patient is detained, and appropriate medical treatment is available to the patient. Also bearing in mind that really important new definition of appropriate medical treatment. And then same principle for community treatment orders. You're referred back to the criteria under Section 17A for that tribunal to then apply those criteria when considering an application for discharge. Now, importantly and interestingly, so the power to make statutory recommendations for patients detained under civil sections, which it exists at the present time, is retained but slightly changed. So the tribunal can still make a statutory recommendation with a view to facilitating the patient's discharge at a later date, and that would be a recommendation for leave of absence, transfer to another hospital, guardianship, or, what most importantly, for the responsible aftercare bodies to make plans for the provision of aftercare services for the patient. So 2 things to note here. CTOs seem to have disappeared from the power to make statutory recommendations, and there's now this new power which will be for the tribunal to ask the responsible authorities, so local authority and ICB responsible for the aftercare of the patient, to make plans for that provision of aftercare services. So here, the proposal to enable the tribunal to have a power to actually direct services in the community has gone, but there is provision for a statutory recommendation that they make those arrangements. And again, still the power which exists now to reconvene if that recommendation is not complied with. So it is persuasive, it's not directive, as it were. The tribunal, of course, can't make aftercare services available, but it can now direct for aftercare services to be thought about at least, and for reports to be provided about that, and then it can reconvene if that recommendation is not complied with. So that might be a useful power to use for patients who are stuck without aftercare services being properly arranged in the community. So for forensic and restricted patients, I think overall the theme of this bill was that there aren't as many changes for them as there are for those subject to civil sections. And maybe it's slightly forgotten about group, I think, actually, this group of patients who are admitted to hospital as a result of contact with the criminal justice system. Again, so section 37 patients, the requirement when looking at an application for discharge is to look at relevant disorder instead of psychiatric disorder when they're looking at the criteria under section 20, paragraph 4. Don't know whether you're confused, I am. Relevant disorder, mental disorder, psychiatric disorder. I think that's one of the issues with the bill, really, that there's these different references and definitions. So this is really to encompass the fact that people with autism and learning disability are still going to fall under forensic provisions, effectively. So you can still be detained as a result of a court order in the criminal courts if you have autism or learning disability. And then for restricted patients, again, so looking at section 73, the power to discharge restricted patients. So the tribunal will direct absolute discharge if the section 20, paragraph 4 criteria are not met, and if the power of recall is not appropriate. So in some ways, no change there in terms of provisions for conditional discharge for patients. So again, same caveat here, the criteria should be read with reference to relevant disorder, not psychiatric disorder. And relevant disorder meaning psychiatric disorder, autism or learning disability with serious behavioural consequences. Now, the other big change for forensic patients is the power to discharge someone subject to conditions amounting to deprivation of liberty. So mental health lawyers will remember the Supreme Court case of which says that you can't conditionally discharge a patient to conditions amounting to deprivation of liberty, which has caused a lot of practical problems, I think, for this group who do require those conditions to keep them safe when they leave hospital. And it does seem to cause a big problem. I had a case this month actually where a patient hasn't been discharged. He's decades and decades post-tariff, hasn't been discharged because of a dispute between the local authority and the treating team about whether or not the patient has capacity to make decisions about residence and care. So they can't conditionally discharge him until they know if they can deprive him of his liberty in the community. We've had to ask court protection to decide on capacity. So I think for this group of patients, they have been a bit stuck, and this section is the answer to that, which is going to apply. At the moment, it says it applies to references to the tribunal, so question mark around applications. But if there is a proposal for conditions that amount to deprivation of liberty for the patient and they're necessary for the protection of other persons from serious harm, then they can be discharged subject to those conditions. If it would be no less beneficial to their mental health than for them to be recalled to hospital. So I think reading between the lines, what they mean there is if it's less restrictive for them to be in the community deprived of their liberty than it is to be in hospital, and it's no less beneficial for their mental health, and that's a power that the tribunal is going to have to set conditions amounting to deprivation of liberty. Now, if you do discharge a restricted patient subject to deprivation of liberty, there's going to be increased access to the tribunal, so every 6 months and then every 12 months in terms of reviewing those conditions. So potential issues for discussion around tribunal powers and proposals in the bill. So there's a few things that I think are missing and were considered in the review and various reports previously. So there's no statutory recommendations for restricted patients. The tribunal still doesn't have the power to make any recommendations about patient having leave or being transferred to another hospital. So some of those restricted patients who are really stuck and need a change of scene or they need to access leave, the tribunal still isn't going to have any power to make statutory recommendations about that. There's no power to direct that aftercare can be arranged. There's no power to appeal treatment decisions. That was something that was considered at one point. So again, if you are objecting to the treatment you're being given in hospital, your only legal recourse really is going to be judicial review. And as we all know, that's not really a proper legal resource, very difficult to access, and persuading the administrative court to interfere with a medical decision is incredibly difficult anyway. So there isn't going to be that appeal currently in the proposed bill around treatment decisions. The different criteria for civil sections versus restricted patients, so psychiatric disorder versus relevant disorder, and I think that some people feel that is going to cause some confusion, and consequences for learning disability autism patients. I think Oliver's going to cover that in some detail, but thinking about the differences between civil and forensic sections, the fact that people with learning disabilities and autism can still be detained via the criminal justice system is a concern, I think, for many as well. And significant additional resources that are going to be needed. So there's going to be a significantly larger number of tribunals, potentially double the number for people who are detained under Section 3. So how is all that going to be provided for in terms of tribunal service, but also legal representation for patients? And I know we've got a number of mental health solicitors in the room who all work incredibly hard on very small fixed fees, and they're really a dying resource, and we need more of those legal representatives, and there's going to be a real need for those going forwards with increased access to the tribunal. So how is all that going to be arranged? What are the timescales? When the resources going to be in place to actually be able to implement this bill? So that's me. Obviously, I look forward to having a more detailed discussion with you all in my session, which will be about mental health tribunals on a date to be confirmed, probably in May. So watch this space. If anyone had any questions, I'll go back.
Lovely. Thank you very much, Elizabeth. It was extremely interesting. Maybe I could ask a question which has been asked online, which is there any indication yet of what the transitional provisions will be?
That's a very good question. I'm not sure I have the answer. I don't know whether Sophie has.
What I do know is, as I said, it is going to be an incremental process. And I think the idea is that different reforms will get switched on at different times. Now, I think the nominated person one might be one of the earlier ones. And I know that the sort of learning disability and autism is going to be one of the last ones because, well, quite.
Because the resources aren't there.
Yeah,
yes.
because it involves resources. I don't know how the rest of them are going to be staged, and I don't know what the transitional arrangements will be.
Thank you very much. Any questions in the room, Elizabeth?
I just ask, when we get to core sort of conceptual tests, serious harm and the, what's it, not foreseeability of the serious harm, and then the foreseeability of
The
harm.
likelihood.
Of
Yeah.
that's it. Are there any changes to who will be the arbiter, and any changes as to where the opinion evidence will come from to decide? Because they appear to me to be pretty essential thresholds. Otherwise, these rights are empty.
As well. So I think, I mean, in terms of admission, it's going to be the 2 medical recommendations, application from the approved mental health practitioner.
So
and
that,
in terms,
that hasn't changed.
so that won't change.
Yeah.
And in terms of the tribunal will have, as far as I'm aware, the same composition.
Yes.
I don't think there's any proposed change. So,
But there are no discussions about changing the wiring.
but changing who was going to be making the
Where the opinion evidence comes from and who decides.
Trying to remember whether there were answers.
Well, there's a question or an observation here from Rebecca saying tribunal service is already in crisis. With a lack of judges, it will be chaos. I think there is a proposal, is there, or not a firm proposal, to go over to single judge tribunals?
Well, that was one of the options that was considered, wasn't it, to do treatment?
Yeah, to appeal treatment decisions. So it was going to be a tribunal judge and a medical member, wasn't it? So that hasn't been taken forward. So as far as we're aware, there aren't any proposed changes to the tribunal composition.
Thank you.
There's another question. It's in the form of an observation. It's from Anne Memot says it's a tricky situation over the definition of serious behavioural consequences. One would assume there would be a test based on, e.g., likelihood of major injury, but some of the behavioural teams use very different criteria that are not backed by external research. Unfortunately, not all legal teams are aware of this. I don't know if there's any observation that either of you
I mean, I
want to
think
make.
I think some of these concepts are slightly woolly, aren't they? I think the serious harm test in particular, in terms of how you define that. So there's undoubtedly going to have to be some case law, I think, on these issues to provide us with a bit more guidance on what that means and what that threshold is, because I think it is a bit woolly in places.
And I think they're proposing that the code of practice is going to try and, you know, set out some scenarios and give some initial guidance as well. But I mean, that's a, you know, that is a very good point, and that's one of the points that was being made in the House of Lords yesterday. Go on.
We have the microphone, please. Thank you.
Yeah, it seems to me there'll be a lot of human rights challenges, because isn't my understanding around the Human Rights Act is that it needs to be kind of clear of which it needs to be not too arbitrary to allow for complete discretion. So is there I imagine there would have to be some interaction with the Human Rights Act and possibly Article 8 and 5, you know, deprivation of liberty and right to privacy, family life, regards to treatment and things like that.
Yeah.
So I imagine there would have to be, because the courts, the law has to be written in such a way that it can't just be applied nilly-willy. There has to be clear criteria. Yeah.
Mm.
So I imagine there'll be quite a lot of human rights cases.
Yeah, and it will be interesting to see what the Human Rights Committee say about
Yeah,
it.
if they bother to engage with people with learning difficulties, nothing in easy read. I've just gone there. We knew nothing about this joint committee of human
Yes, I
rights.
know.
Yeah, nothing in easy read. So yeah, so we're
it's
getting
not
on the case
encouraging.
tomorrow.
No,
Yeah.
you do. Yeah.
But we will be getting on the case to them because we feel that that's wrong. Okay.
Thank you.
But
Simon.
yeah, we see if you had us involved, then we'd be doing everything under the UNCRPD.
Thanks, Simon.
So the suggestion here that the government should provide more resources in the community before implementing this.
Yep, absolutely.
Yeah, and that's the plan, as far as we understand it. Yeah.
Yeah. And that was a really clear recommendation right through the review process as well, wasn't it? It was, you know, it was.
Yeah, it was. Can I ask about the discrimination? I mean, so far we've not had anything. But one of the reasons Theresa May set up the review was that Black British citizens are 4 times more likely to be detained and 10 times more likely to be on a community treatment order, even though the fact that they're in the community means that the risk can't be all that significant or immediate. So that was one of the main reasons for this review. Doesn't seem to be any additional safeguards built in to the legislation for Black citizens.
I
Did
don't.
they address that in any way?
I think that's one of the criticisms of it, that there isn't enough of that. And I mean, there were recommendations around specific advocacy services as well, weren't they, for BAME communities? So we'll need to see whether resources are put in to deal with that. But with CTOs, I think there's some surprise really that they're still there in the bill, bearing in mind not just the evidence of their impact on BAME communities, but also the fact that there are studies that say that don't prevent readmission, that seem to have any particular impact really for most patients on preventing readmission to hospital in any event, which was the idea behind them. So I think maybe a bit of surprise that they're still alive, CTOs really.
Thank you. Any more questions? Okay, well, I think maybe it's a good time to move on to the last talk, which is from Dr. Oliver Lewis, who is a very well-known international human rights expert who worked with Validity, I think, for 15 years, and who was involved in the introduction and implementation of the UN CRPD. So he's going to talk to us about learning disability and autism issues. And maybe you could, at the end, just give us your view as to the question raised earlier about the CRPD and whether this legislation complies with it.
Thank you very much. Thank you for that kind introduction, and I'm going to have to get used to not calling you judge, so apologies if I slip into that vernacular. I'd like to make my observations starting with the CRPD and frame what I'm going to say within the context of the international human rights framework, and most specifically Article 19 of the UN Convention on the Rights of Persons with Disabilities, which is the right to live in the community and be included. And although the CRPD isn't embedded into law, the UK has ratified it as an international treaty, and so it has obligations to implement it. And my headline analysis is that this bill does very little to implement it. The CRPD is essentially a civil society derived text, which the states then took and manipulated and agreed. And in that vein, I'd like to welcome all the campaigners in the room and online. I know that there are very many. So the self-advocates, the lay advocates, the family members, the warrior mums in particular, and the allies who've been fighting the corner for many years and banging the human rights drum. So thank you for what you do. But what has mental health law got to do with people with learning disabilities and autistic people? Well, from the perspective of many patients detained under the Mental Health Act who have learning disabilities and who are autistic, all that a mental health law does is to make lawful acts that would otherwise be unlawful. So false imprisonment becomes lawful detention. Injecting chemicals that alter your mind and your body becomes necessary and therapeutic treatment. That framework, the mental health law framework, makes very little sense for people who are autistic or who have learning disabilities. And what makes more sense, in my view, is if we look at the bill and the whole the legal framework through the lens of the social model of disability, which, as is well known, locates the problems not in the person, but within disabling barriers in society, environmental and financial barriers for sure, but importantly, in our context, legal and attitudinal barriers as well. So what are the numbers? Let's just remind ourselves that NHS England produces monthly statistics. So we know that last month there were 2,050 people with learning disabilities and or autism who were inpatients in mental health hospitals. 92% of them were detained under the Mental Health Act. And interestingly, around half, so 1,100 people, just over half, were detained under Section 3 of the Mental Health Act. Very few were not detained under any provisions of the Mental Health Act, and the rest were detained under what we call Part 3, or the forensic or the criminal sections. And as Liz has said, it would still be possible for an autistic person or a person with a learning disability to be detained because of their learning disability and autism under Part 3. And I've been thinking, you know, that would be or the legal change would be to remove that cohort of people from the civil detentions. But an interesting question is, what's the moral difference? How can you, I'm sure you can justify it in law because law is law, but like, why does that make sense from a moral perspective? I don't want to answer that because I'm not sure that that it does make sense. Another interesting feature of the statistics is that the people involved have changed slightly over the past 9 years. I think statistics started being collated in 2015. So now 30% of that overall cohort have learning disabilities without autism, 30%. 50% have autism without a learning disability, and 20% have both. Maybe we can take the diagnostic accuracy with a pinch of salt, I don't know. But looking back at 2015, the data were that 54% had a learning disability without autism, 15% autism without learning disability, and 23% both. So the sort of center of gravity shifted. And if you go back more decades, then it certainly has shifted from being predominantly looking at people with learning disabilities to grappling with and providing services and understanding neurodiversity. And in my experience, doing a lot of these cases, it's neurodiversity that is the least understood, even if neurodiversity presents with someone who also has a learning disability. 52% of the overall cohort have a total length of stay over 2 years, but that does include the forensic people. 70 have been detained under the Mental Health Act for more than 10 years. Around a fifth of the overall cohort have a date where it's planned for them to leave hospital. 51%, so the majority, have no planned discharge or transfer date. So that's the quite gruesome picture in terms of statistics. And we all know that the government has set itself many, many targets over the course of, since the Winterbourne View scandal, and set itself targets, all of which have been missed. And so the community of people with learning disabilities and NGOs representing, and which are not just representing, but autistic people and their representative organizations, think that it's really nonsensical for the NHS to spend millions and millions of pounds on detaining people in the wrong place with the wrong approach that causes them harm. And even the Mental Health Act Code of Practice recognizes one of its clearest points, and paragraph 2020, so I always think this is like 2020 vision here. It says compulsory treatment in a hospital setting is rarely likely to be helpful for a person with autism. Surprise! Who may be very distressed by even minor changes in routine and is likely to find detention in hospital anxiety provoking, etc., etc. And from my caseload, I know, and people in this room also know, that mental health units are or can be dangerous places that cause physical and emotional harm. And I've many clients who have PTSD as well as their family members, thanks to the hospital admission. And the admission has made them and their family members worse. And isn't that, just thinking about that you have a hospital admission that makes you worse, and millions of pounds have been spent on the pleasure of being detained. And the Mental Health Act, one of the aspects of it is that it's a system whereby the psychiatrist, the responsible clinician, has almost unlimited powers. It's virtually impossible to challenge the responsible clinician's decisions. So they can exclude, in cases that I've dealt with, they've excluded family. They have stripped the patient of autonomy in all areas of their life. And it's very easy to justify detention in hideous conditions, especially if there are no community alternatives. And families place all of their hope sometimes in the Mental Health Tribunal, which has the powers to direct the discharge, but the tribunal will not direct someone's discharge unless they have somewhere safe to go to. So that's why actually helping people get out of hospitals is much more challenging than just using the Mental Health Act and going to a tribunal. You have to sometimes, in cases that I've done, use 4 or 5 areas of law, including the Mental Capacity Act, the Equality Act, the Human Rights Act, as you've mentioned, civil claims, and the Care Act, so community care. One of the challenges is that there are very few law firms, very few solicitors that you can go to who have contracts with a legal aid agency in mental health law, Mental Capacity Act, so court of protection stuff, and community care. Very few, and that's the Holy Trinity. Very few firms have that. And so there are realistically only a handful of lawyers doing this line of work for over 1,000 potential clients, right? And not all of those people have, I mean, very few of that 1,100 people who are detained under the Mental Health Act have lawyers who are in a position to, especially for the delayed discharge people, to try and get them out and also secure a community discharge destination. So we know that there's been debates in Parliament, and a parliamentarian has said this, quote, "The hospitals have had to provide beds for people who, had they had reasonable homes to go to, would have been sent out of hospital to their homes. And the hospitals have, as a result, not been able to concentrate upon the cure of people who are mentally ill with all those rapidly expanding weapons of treatment," end quote. So that wasn't the House of Lords debate on the 25th of November or the recent committee hearings. That was Sir Keith Joseph, MP, in the House of Commons debate on mental illness and mental deficiency on the 8th of July, 1957. And the same is true today, right? So there's really been little change since the Mental Health Act of the 50s, and then it was sort of updated in 83. And in my view, focusing on the rights of people with learning disabilities and autism, the Mental Health Bill would do very little to advance the rights again, and this is a huge missed opportunity. But what exactly are the proposals? And I know that I don't have much time left, but this has largely been covered actually by previous speakers, because there really isn't very much at all. So 2 things, the bill says 2 things that are already happening, but just not happening in the Mental Health Act. One is care and treatment reviews, CTRs. So it puts that inside the Mental Health Act. Well, those are happening already, and they have very limited power. They're great, fantastic, usually, say amazing things, but there's no linkage between them and the tribunal. They have actually no powers. The bill would place a new duty on various people, including the responsible clinician and, importantly, commissioners, like local authorities or ICBs. And so listen to this fantastic new duty in relation to those, which places the duty on those people in relation to CTRs. Those people would have to, drumroll, have regard to the recommendations. Fantastic. The bill would also place dynamic risk registers into law, but those exist already as well. And then my colleagues have not stolen the thunder, but like there's not very little to say about, then the other big thing is removing the words learning disabilities and autism from the purview of Section 3 of the Act. And it does that in various complicated ways that my colleagues have already explained. And then there's an idea that that last bit is going to be delayed for several years with the hope that there might be some community support services and billions of pounds spent on accommodation and things like that. And going back to our friend Sir Keith Joseph in 1957, he said this about delay. "No one doubts the goodwill of local authorities. No one doubts the skill of their officers and the interest of their citizens, but this is a mammoth task, and we should ask ourselves whether this revolutionary increase of local responsibility and power can be satisfactorily managed quickly, or whether we must be content to move slowly and securely, building up the staff and buildings and the cooperation which will be so essential, end quote. So this weighing up of whether we should just go for it or just really slowly build up the community support services, that's been a debate that's been in parliamentarians' minds for over half a century. So my view, for what it's worth, is that it's wholly inappropriate to delay the entry into force for several years, and also that the Act has to contain better provisions that actually place proper duties on public bodies to get detained people out of the mental health system and into the community with good quality housing and care that meets their needs and accords with their choices, and prevents future admissions. And this is a golden opportunity, but the amendments as currently drafted are wholly inadequate to advance the rights of people with learning disabilities and autism. They do nothing to implement Article 19 of the CRPD. They shift the dial a little bit, but not far enough. And you will note that the bill's explanatory notes detail, quote, significant financial requirements, not commitments, for implementing the reforms, including £2.5 billion for housing and care related to reforms for individuals with learning disabilities and autism. That's the requirement. So going back to Anselm's point, the government really values autistic people and learning disabilities. But without legal duties, I don't think that anything will change really, and we'll be stuck in another generation cycle of inaction and excuse. So if today is not necessarily the deep dive, but the shallow snorkel, and my pupil Jordan here threatens to create an AI image of me snorkeling in a mankini, which I'm now officially prohibiting. If today's the shallow snorkel across these different areas, we're going to be doing a deep dive into the specific issues that we've touched upon. And on the 28th of April, we will hopefully in the afternoon be having a workshop for people with learning disabilities and autistic people. And then at 6 o'clock, having a more kind of public-facing seminar and webinar. But the sort of things that I think we'll be debating and suggesting on that date are to ensure that if people with learning disabilities and autism can't be detained under Section 3 of the Mental Health Act, how can we prevent them from simply being deprived of their liberty under DOLS, under the Mental Capacity Act? Because the vast majority, if not everyone in that cohort, is likely to lack capacity to make those decisions. So that's what's going to happen. And if services aren't ramped up, then Part 3, the forensic provision, still remains. And given the increased criminalisation of behaviours in mental health and social care settings, it's going to be likely that more people with learning disabilities and autism end up going into prison or under Part 3 of the Mental Health Act. We know that half of detained patients with autism and learning disabilities have another label, like personality disorder. So that other label will become the front label, as it were, and then they'll be able to be detained under Section 3. And the Act doesn't say anything about the reasons why people with learning disabilities and autism end up being detained under the Act, which is some sort of crisis or breakdown in the community, in my experience, either relating to housing provision or a breakdown of care package or support. It doesn't do anything. It doesn't say anything about those things. It says that it wants to prevent admissions under the Mental Health Act of this group, but doesn't actually address why people are being admitted. And so I have some ideas which are not in the bill. So for example, just to flag these and then I'll finish, changes to Section 117, which is that's the golden nugget in the whole Act. That's the only economic, social, cultural rights in an Act which otherwise removes people's civil and political rights. That if you've been detained under Section 3 and some other long-term sections, you have a right to aftercare. That includes housing and care, not just mental health treatment in the community. It's a brilliant provision. But in my view, that should be amended to create financial incentives, but also penalties on local authorities and ICBs who have the joint responsibility to get people out of detention and identify and place people in a community provision, because they're very happy. Those local commissioners are very happy for so-called complex cases, for people to be detained under the Mental Health Act for years and years and years, because they don't have to pay for that. But as soon as they come out, these so-called complex patients will require a high level of support, and the community support is going to be very costly, right? So that's one of the key blockages, and I've had many cases where it's clear that that is going on. Another idea is that in order to get or to facilitate the discharge of people with learning disabilities and autism currently detained under the Act, there should be some sort of automatic referral to the Court of Protection on delayed discharge, because the Tribunal is ineffective. It's only the Court of Protection that can direct the public bodies to provide evidence about what their plans actually are. And there needs to be provision for families to be represented and for them to have legal aid rather than not be represented at all, or rely on the very few number of people who would be prepared to do these epic cases on a pro bono basis. And another idea that is being discussed in the communities are to give the CTRs more power or teeth, or somehow kind of match them up in a structured way with the tribunals. Monday, 28th of April, we will resume this conversation. Those are just some ideas. I don't have any budget to organise anything in relation to the 28th of April. We can give you, the community, we have this space and we have ourselves. We are doing this pro bono, as it were. But it's really important that people with learning disabilities, as you've said, Simone, are able to gather together and their families and advocates to come together to debate these proposals and to make sure that parliamentarians know their views, but also to come up with some practical solutions. And then the lawyers, we can do some drafting and be in touch with NGOs and pass on those ideas, which hopefully might have the potential to advance human rights in a way which the bill, as currently drafted, simply does not. Thank you.
Thank you very much, Oliver. That informative and disturbing in many ways. Paul, I think we've got time for maybe 2 questions. Yes. Do we have a question for Oliver? I mean, one of the things that concerns me is just how fluid the different classes of mental disorder are. So in the old days, when I started, we had 4 categories of mental disorder. And if somebody, particularly in the special hospitals, recovered from mental illness, went into remission, instead of being released, they were reclassified as having a personality disorder, a psychopathic disorder. I'm just wondering, with this learning disability change, whether the people on section 3 will actually just have an additional diagnosis of a type of mental illness or a personality disorder that precludes them being discharged.
Yeah,
I don't know whether you have a view on that.
Yeah, I'm almost sure that will happen. I mean, that's happening already. You know, it's quite well known, and there's debates within psychiatry about the tendency for a person who has autism as a young person to sort of graduate into personality disorder. That's a journey that certainly practitioners see quite regularly in the autism community. That's discussed, and then there's a huge debate within psychiatry. So there's relabeling, and the labels are rather porous. But then it's going to be up to judges, isn't it? I suppose, to say, well, what's the predominantly, or what's the presenting? I don't know. What's the 51%? Is it, you know, I don't know how that's going to work, because otherwise it will be just possible to justify detention.
I think
under
it's going to
Section
be
3.
really tempting for psychiatrists to find an additional diagnosis in someone
Yeah,
within that period of Section 2 detention, and I've seen that all the time, and I've had
Yeah.
people with autism diagnosed with bipolar and all sorts of things.
Mm.
You know, which if you actually sit them down with a specialist, it's quite clear that a lot of it can be, or, you know, their presentation can be explained by their autism spectrum. And
Yeah.
I think it's going to happen more and more.
Issue seems to be people have physical conditions related to their autism when they don't get their needs met, physical, that ends up having an impact on their mental health, and therefore actually what is a physical condition that needs to be looked at becomes a mental health condition to be treated, because hospitals, psychiatric hospitals, do not have the expertise to work out whether this is a physical condition, because quite a lot of people who are autistic have other physical health conditions. You know, certainly there's a couple of them who keep coming to me and reminding me to make sure those issues are addressed. And the mental health bill does absolutely nothing of that. The psychiatric hospitals don't do any of that. But it seems to me what this bill allows for is still this discrimination, that disabled people are the only group of people that can be locked up for doing nothing, locked up for not doing locked up for doing nothing other than being themselves, locked up before you have a trial, before you see a judge, you know, and also that it seems very clear to me that this bill definitely does not comply with UNCRPD's monitoring committee's recommendations that came out from the monitoring committee's review of UK's performance. So we're very keen to, one of the things that we're asking for is, and we've put it down as an amendment, but obviously it didn't get debated, was around that was the one thing that we wanted was to actually ensure that that there was full implementation of all the recommendations for the UNCRPD monitoring committee that actually talked about the place of non-consensus treatment, around detention, etc. So that's what we've been asking for. Please have a look on our website, www.inclusionlondon.org.uk, and the 3 Hour People campaign, and talk to me afterwards. I'm very keen. I get patients, people who are struggling in the community to stay out of hospital. And they come to me and say, we have no lawyers. We try and get them and we can't find them. If they're in this room and they want to say, yes, we want to work with people learn to call these autistic people directly, with or without supportive families, please let us know, because we are very keen to ensure that anybody comes to our network who asks us for any assistance. I'm not a lawyer. To please do contact us at Inclusion London. I'll give you my details afterwards. So this is really this is our opportunity to work together. So yeah, so I'm around.
Thank you,
Okay,
Simone.
and we're on the lookout for great lawyers.
I think we're out of time. Thank you for 3 excellent talks. So that has set the scene for the series of seminars. And the next one is on the 27th of February. That's detention and consent to treatment. learning disability and autism is on the 28th of April. That's a hybrid event. And then in May, but the date's still to be fixed, to be tribunals and aftercare. And in June, it will be mental health and structural racism. So just before we finish, we have some refreshment. I hope that you will stay and socialise, but I'm sure you'd like to finish by thanking our